In the criminal justice system, the people are represented by two separate yet equally important groups: the police who investigate crime
and the SJW district attorneys who don't prosecute the offenders. These are their stories. Why is my channel called The Prosecutor? Well, my original intention for this channel was for it to focus on SJW prosecutors. Prosecutors who are doing stuff like not charging illegal immigrants with felony offenses because they might get deported. A lot of my old videos focus on this topic. Now that the McCloskeys have been charged with felonies, it's time for some good old-fashioned prosecution channel content. As we all know, Black Lives Matter surrounded the home of the McCloskeys. The protesters were on their way to the house of the mayor of St. Louis when they decided to make a pit stop. Mark McCloskey armed himself with an assault rifle, which he held with the barrel pointing towards the air. Patricia McCloskey held a handgun that she often pointed directly at the protesters. Now the couple has been charged with the crime of unlawful use of weapon. This crime is committed when a person knowingly exhibits, in the presence of one or more persons, any weapon capable of lethal use in an angry or threatening manner. Let's do some legal analysis. Is the Missouri prosecution of the McCloskeys legal? Let's start our analysis with the Missouri Constitution. Article 1, Section 23 of the Missouri Constitution protects the right to keep and bear arms. Notice the distinction there between both keeping and bearing of arms. To bear means to carry something. So when do you have a right to arm yourself? Well, according to the Missouri Constitution, you do in defense of your home, your person, property, or family. So right off the bat, it appears that any prosecution of the McCloskeys would flagrantly violate the Missouri Constitution. Now let's move on to Missouri statutes on self-defense. Title 38, Chapter 563.041 authorizes people in Missouri to use physical force upon another in the correct situation. That situation is when he or she reasonably believes it's necessary to prevent the commission of theft, property damage, or mere property tampering. Now, the statute also has special requirements for the use of deadly force. Missouri's definition of deadly force requires one to act purposefully to cause a substantial risk of death. Notably, the McCloskeys never used deadly force. Their firearms were never discharged. Merely pointing a gun at a trespasser is not the use of deadly force. If it was reasonable for the McCloskeys to believe that their property may be damaged or tampered with, Missouri law authorizes them to use force. It would have been reasonable for them to fear property damage from a mob of Black Lives Matter protesters trespassing on their property. I attempted to research case law on the unlawful use of weapon charge, but I didn't find many relevant decisions. The lack of published case law suggests to me that this crime is rarely charged. The little that I did find made it clear that a conviction requires the gun to be held in an angry or threatening manner. In the videos we have, the protesters are so loud you can't even hear what the McCloskeys are saying.
Shit from you. I'm gonna take it from you. I was in fucking Afghanistan, you fucking bitch. I've been shot at before. I'm not gonna be afraid of you, fucking cunt.
In the street, please. I got you. In the street.
Fuck you. Fuck you.
You got your money shot in the street. In the street, money shot, you got it.
They're greatly outnumbered and surrounded by protesters who are screaming, some of which have megaphones. Given the circumstances, one can hardly say that the guns were being held in an angry or threatening manner. To further explore the law, I looked up Missouri case law on self-defense. One case that I located was State v. Mosley. John Mosley was the manager of a movie theater. Someone kept trying to break into the theater through a locked side door. Upon hearing the door handle being manipulated and afraid that this person would eventually break in, John Mosley fired 2 shots through the door. Unfortunately for John Mosley, the person on the other side of the door was a police officer, one that had been dispatched there because someone else had called 911 to report that someone was trying to open that same door earlier. So Mosley accidentally shot a cop. The Missouri Appeals Court upheld Mosley's conviction because shooting at a door that he knew someone was behind was the use of deadly force. Although not addressed in the opinion, I'd argue that the decision implies that merely arming yourself without discharging a weapon would constitute a permissible use of force in this sort of situation. Another bizarre case I found was State v. Beckham. R.F. Beckham owned a chili stand which had been the victim of repeated burglaries. To protect the property of the chili stand, Beckham created a trap involving a gun that was tied to a window. If the window were open, the gun would discharge. Beckham testified that the barrel of the gun was not pointed at the window, but at a wall. He indicated he didn't want to kill any potential burglars, but just scare them away. When a teenage boy was shot and killed by the trap gun after opening the window, Beckham testified that the gun must have shifted out of place. The Missouri Supreme Court said the trap could only be justified if Beckham himself could have used deadly force if he were actually physically present. Because Missouri law does not allow deadly force to be used to defend property, the Supreme Court affirmed Beckham's conviction. It did indicate, however, that had Beckham been physically present, he would have been entitled to conduct a citizen's arrest of the teenager at gunpoint. This is because the deceased victim would have committed burglary, which is a felony. Now, these protesters did not commit a burglary. That being said, I do believe that their conduct constitutes the crime of rioting under Missouri law. The crime of rioting is committed in Missouri when someone assembles with 6 or more people, all in violation of a criminal law. That seems to fit what was happening in this case, where you had this mob of people who were all trespassing on private property. Missouri's citizen arrest statute permits a citizen to arrest someone who commits an offense in their presence. If the McCloskeys would have been legally entitled to arrest these protesters, which I believe they would have been, I have to believe they'd be legally able to bear arms to protect themselves. So the McCloskeys' indictment is a farce. It violates Missouri's Constitution. It violates Missouri's defense of property law. The McCloskeys' conduct also probably doesn't even fit the elements of the offense. So why are they being prosecuted? The decision to prosecute the McCloskeys was made by Circuit Attorney Kimberly Gardner. Kimberly Gardner was elected in 2016 after her campaign was generously financed by George Soros. Upon getting elected, Kimberly Gardner immediately began using her office for partisan political purposes. Her first target was Missouri's Republican governor, Eric Greitens. She accused Greitens of blackmailing a woman that he had an extramarital affair with. Notably, the supposed victim of this crime was not cooperative with Gardner's investigation and did not want Greitens prosecuted. During a deposition, an investigator working with Kimberly Gardner lied under oath to the supposed victim of the blackmail. Since Kimberly Gardner was present for the deposition and aware of the perjured statements, she became a witness in the case. Now that the case had been bungled, Kimberly Gardner ended up dismissing it during the jury selection. As a result of this, a special prosecutor was appointed to handle the case. Rather than refile the case, though, the special prosecutor, Gerard Commodi, ended up indicting Kimberly Gardner's investigator for perjury. In December 2018, the Missouri Ethics Commission found that Kimberly Gardner had engaged in 355 campaign finance violations. As a result, they ended up fining her over $63,000. Gardner later made a deal that allowed her to pay only 10% of the fines in exchange for paying them off in a short period of time. If I were a Missouri taxpayer, I'd be absolutely appalled by how lazy the attorneys staffing the Ethics Commission are to agree to something like this. Kimberly Gardner's next controversy arose after she sought the indictment against 2 police officers. This indictment concerns a shooting that took place in 2018 in a bar called Bomber O'Brien's. One of the officers Gardner sought to charge had himself been shot during the incident. Gardner impaneled a grand jury, but that grand jury refused to indict the officers based on the evidence presented to them. So Kimberly Gardner impaneled a second grand jury, which did choose to indict the officers. However, Kimberly Gardner refused to provide a grand jury transcript to the attorneys representing the officers. When a judge finally ordered her to provide the transcript, more misconduct was uncovered. Kimberly Gardner had failed to tell the grand jury that the victim's statements were provided only after being offered a deal in his criminal case. She also withheld from the grand jury the actual video recording of the shooting. As a result of this revelation, Circuit Judge Elizabeth Hogan found a pattern of misconduct existed on part of the prosecution. She therefore sanctioned Kimberly Gardner and dismissed the case against the two officers. In January of this year, high-ranking Chief Trial Assistant Rachel Smith resigned from Kimberly Gardner's office. Smith had worked as a prosecutor at the office for over 19 years. Since Gardner took over as circuit attorney in 2016, 65 prosecutors have either quit or been fired by Kimberly Gardner. That same month, Kimberly Gardner filed an absurd lawsuit under the federal Ku Klux Klan Act. The defendants in the lawsuit included the City of St. Louis, the St. Louis Police Union, Special Prosecutor Gerard Commody, as well as Gerard Commody's children. Gardner's lawsuit also included Charles Lane as a defendant. Charles Lane is a former St. Louis police officer who had sued Kimberly Gardner the previous year. That lawsuit alleged that Kimberly Gardner had used hundreds of thousands of taxpayer dollars to hire private law firms to represent her in all of these numerous controversies. Gardner's lawsuit, filed under the Ku Klux Klan Act, alleges a racially motivated conspiracy to violate the civil rights of black people. Attorneys consulted by St. Louis local media indicated that the lawsuit was meritless and doomed to fail. Of course, that won't prevent the city of St. Louis from spending millions of taxpayer dollars hiring outside law firms to defend itself and defend all of the various defendants listed in the lawsuit. So why are the McCloskeys being prosecuted despite their obvious innocence? It's because the circuit attorney for St. Louis is a joke. Her entire administration is a joke. She's not reforming the justice system. She's just wasting taxpayer money with nonsense, political corruption, and ultimately prosecutorial misconduct. That's all I've got to say on the saga of Kimberly Gardner versus the McCloskeys. If you enjoyed this video, support small YouTube channels like mine by subscribing. Thanks.